Bismillah ar-Rahman ar-Rahim. Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome to another session of this course on Islamic inheritance law. In this session, we shall be looking at the subject of impediments to inheritance within Islamic law. Let's start off with text from the Sirajiyya al-Mani'u min al-Irth Arba'a. أرق وإفرا كان أو ناقصا والقتل الذي يتعلق به وجوب القصاص أو الكفارة واختلاف الدينين واختلاف الدارين إما حقيقة كالحربا والذمة أو حكما كالمستأمن والذمي أو الحربيين من دارين مختلفين والدار إنما تختلف باختلاف المنعة والملك لانقطاع العصمة فيهم. An impediment to inheritance arises from either an act committed by the barred individual or a quality he or she possesses barring them from inheriting. A disqualified heir, known as mahrum, cannot exclude others from inheriting. The mahrum is treated as if they do not exist. However, according to Hadrat Abdullah bin Masud radiyallahu anhu, such a mahrum can still partially exclude remaining heirs. For example, a man who intentionally kills his father, though disqualified himself, will still reduce the widow's share to 1/8. In contemporary Islamic law, three recognized impediments include homicide of the propositus by a potential heir, a difference of religion between the heir and the deceased, and a difference of domicile between the heir and the propositus. For the sake of completeness, we should mention slavery as the fourth impediment to inheritance. According to the Hanfi fiqh, any killing whatsoever will prevent the right to inherit with the following exceptions. 1. Justifiable killing according to Sharia. 2. Killing as a result of self-defense. 3. Lawful killing. 4. Act of a madman or minor. And 5. Indirect killing, referred to as qatl bi al-tasabbub, which does not involve a mistake. In such a scenario, death is not caused by a direct act of the offender, but involves some other intervening act. For example, if a man digs a deep hole in his garden and a visitor falls into the hole and is killed, there is no sin, no expiation, but diyah, that is blood money, is payable. The remaining three madhahib offer slightly distinct perspectives on which types of killings constitute an impediment to inheritance. The Shafi'i fiqh is the most extensive in the application of this particular aspect of the law. The second impediment to inheritance pertains to differences in religion. An individual's religion, in the context of inheritance, is determined at the time of death of the propositus. Three distinct scenarios may arise in this context. Inheritance disputes may occur between a Muslim and a non-Muslim relative. 2. Disputes may arise between a Muslim and an apostate relative. 3. Disputes may involve non-Muslims of different religions. All four main Sunni schools of jurisprudence, that is, the four madhahib, concur that a Muslim does not inherit from a non-Muslim, based on a hadith narrated by Osama bin Zayd radiyallahu anhu, which has been recorded by Imam Bukhari in his Sahih, and by others, which explicitly states, a Muslim cannot be the heir of a disbeliever, nor can a disbeliever be the heir of a Muslim. Some Sahaba, including Mu'adh ibn Jabal and Sa'id ibn al-Musayyib radiyallahu anhuma, and some Muslim scholars, opined that a Muslim can inherit from a non-Muslim based on the hadith of the Prophet sallallahu alaihi wasallam, reported by Imam Bayhaqi, that Islam increases and never decreases. The second situation is that of inheritance between an apostate and a Muslim relative. An apostate is precluded from inheriting from Muslims, non-Muslims, and other apostates. According to the Maliki, Shafi'i, and Hanbali fiqh, Muslims do not inherit from an apostate, based on the general principle that there is no mutual inheritance between a Muslim and non-Muslim. The whole estate of an apostate goes to the Bayt al-Mal. The Hanfi fiqh position is slightly more complicated in such a situation. According to the Hanfi fiqh, based on the view of Imam Abu Hanifa rahimahullah, inheritance from an apostate man is treated differently from that of an apostate woman. Muslim relatives of an apostate man can inherit from him up to the point until he became an apostate. At the point at which a man apostates, he dies in the eyes of Sharia. His heirs do not inherit any property he acquires after becoming an apostate. Such property goes to the Bayt al-Mal. However, under the Hanfi fiqh, the Muslim relatives of an apostate woman can inherit the whole of her estate. Other Hanfi jurists, including Imam Abu Yusuf and Imam Muhammad, do not make a distinction between a male and a female apostate. They hold that the whole of the estate of an apostate, man or woman, is inheritable by his or her Muslim heirs. The third situation is that of inheritance between non-Muslims of different religions. Muslim jurists unanimously agree that inheritance occurs within a single religious community, Millah Wahida, but they differ on defining these communities. The Hanfi and Shafi'i schools treat all Muslims as one community and all non-Muslims as another unified group. Muslims inherit among themselves and non-Muslims inherit among themselves, based on the authentic hadith that a Muslim does not inherit from a disbeliever, nor a disbeliever from a Muslim. The Malikis divide people into three communities: Muslims, Ahl al-Kitab, and other non-Muslims. The Hanbalis fragment people into multiple communities by specific faith, with no cross-inheritance, for example, between Christians and Jews. Citing the hadith narrated by Amr ibn Shu'aib radiyallahu anhu that members of two different religions do not inherit from each other. Besides religious differences, traditional Sharia recognizes difference of domicile, ikhtilaf al-bilad, or wilayat, as a third impediment to inheritance. This refers to heirs owing allegiance to different states, countries, or rulers without any mutual alliance or peace treaty between them. It applies mainly to non-Muslims in the Hanfi and Shafi'i fiqh. One dhimmi, a protected non-Muslim, resident in Dar al-Islam, cannot inherit from another in Dar al-Harb, and vice versa. Muslims in different countries or allegiances face no such bar. They inherit freely from each other, as unity transcends borders. The fourth classical impediment to inheritance in Sharia is slavery, now purely historical, as modern abolition aligns with Islam's trajectory toward emancipation. All Muslim jurists across the four madahib agree that slavery is a bar to inheritance. A slave neither inherits from relatives, nor do relatives inherit from the slave. This stems from the slave's legal status as property forming part of the master's estate, lacking independent ownership rights. In our modern era, with global abolition, this impediment is no longer applicable. This brings us to the end of this session. Insha'Allah, see you in the next one.